Good morning, good afternoon, good evening to everybody who watches this video. My name is Maksim Zhukov. I'm the counsel at Lex Torre Law Office from Minsk, Belarus. For many years, I participate in the organization of Eastern European Dispute Resolution Forum, and I'm happy to present another interview under the auspices of EEDRF Quick and Honest interviews with the most prominent arbitration practitioners. The advantage of our format is that we speak about the most important and actual things in international arbitration in fair and quick manner. And it is a great pleasure for me to introduce our today's speaker, Ms. Jennifer Younan. Jennifer is a partner at the International Arbitration and Public International Law Practices at Paris office of international law firm Shearman Sterling. She has notable experience in advising and presenting companies, state-owned entities, and states in investment treaty and commercial arbitrations conducted under most major institutional rules, and in ad hoc arbitrations with a particular focus on investment and energy disputes in emerging markets. Jennifer is also a member of ICC Commission on Arbitration and Alternative Dispute Resolution, ICC Task Force on Addressing Issues of Corruption in International Arbitration, and Australian Government Delegate to UNCITRAL Working Group number 2 on Arbitration and Conciliation. Jennifer, welcome and happy to see you as our today guest.
Thank you, Maxime. A pleasure to be here.
Our today topic for discussion is ISDS Backlash. What, why, and where to now? It's not a secret for many arbitration practitioners that investor-state dispute resolution mechanism is the subject and point of criticism from different sides, both on the side of investors and especially on the side of states. And Jennifer, could you please explain to our audience, what do we mean when we're talking about the backlash phenomenon?
Thank you, Maxime. I mean, I think the term is generally being used to refer to a variety of criticism, sometimes quite virulent, that has been levelled at the ISDS system in recent years and by a variety of actors, some of which you mentioned, so states, civil society, NGOs, the European Union and academics. I should say perhaps much of that criticism is not new, but I think the intensity of the criticism is perhaps something that was unexpected. And I think that's explained by a confluence of factors. It's explained, I think, a little bit by what we have seen, which is sort of a shift in geopolitical power from what we call the sort of global north to the global south. I think it's explained by a rise in nationalist politics in recent years and perhaps a changing attitude towards globalization. And I think it's also a realization, and we saw this with cases such as Vattenfall, with the Spanish solar cases, that capital exporting states could actually be the respondents in these kinds of cases. So ISDS was no longer perceived as just a one-way street. And so I think there are a number of factors in play that explain what has been referred to in the community as the ISDS backlash.
Oh, Jennifer, can you tell us about what tendencies demonstrate that backlash actually takes place?
I think it's manifested itself in a variety of different ways. There's perhaps a spectrum. There's what I guess is the hard backlash. So states actually disengaging from the ISDS system, either by terminating investment agreements. So we've seen that, for example, with Ecuador, Bolivia, South Africa, or by withdrawing from important multilateral conventions. So the ICSID convention is an example of that. Perhaps moving along the spectrum, we've also seen the renegotiation of investment agreements, and there we're seeing sort of a rebalancing of rights between investors and states. And we've also seen it, I think, in the call by actors such as the European Union for a move away from ad hoc tribunals to a permanent court for ISDS. But I do think we need to be extremely careful here because it's not always clear what these actors are actually reacting to, and it's not always the same. So, for example, by disengaging from ISDS or withdrawing from the ICSID Convention, is that a rejection by states of the ISDS system, or is it more a comment or a concern with globalization generally? Similarly, is the renegotiation of BITs, is that part of the normal reform process, or is that a rejection of ISDS? And I say that because I think there is a danger if we don't sort of analyse this a bit more carefully and perhaps overinflating what has been characterised as the ISDS backlash.
Oh, thank you, Jennifer. And we understand, as I see from the answer to my first question, that there are many reasons for the criticism. Could you explain a little further what are the reasons for this criticism and the criticism of ISDS system?
Yes, of course. Perhaps without addressing it at this stage, whether I think these criticisms are valid or not, which is perhaps a separate discussion. As you mentioned, Maxime, there have been a few different criticisms levelled at ISDS. So one of those is the perception that the system favours investors over states. Another criticism has been the lack of transparency, and certainly if you look at, for example, if you go onto YouTube and you can look at some of the criticism of ISDS, some sort of videos that are out there, they talk about these, meetings happening in secret, behind closed doors. Another criticism has been the lack of consistency in terms of the reasoning in awards being rendered. An example of that is if we take FPS, so the full protection and security provision that you find in a lot of investment agreements, whether that is limited, for example, to physical security or not, you can find awards addressing the same text and the same BIT coming to different conclusions. Another concern being voiced largely by states is this potential chilling effect on the exercise of regulatory powers. And an example that's often cited by critics in that context is the Philip Morris and Australia case, where, for example, New Zealand held off enacting certain legislation related to plain packaging for tobacco, sort of in light of that dispute, sort of waiting to see what the result was. And of course, another criticism is the lack of independence and impartiality of arbitrators. So concerns with double hatting, concerns with repeat appointments. I guess they're the more common criticisms. I think there's also perhaps a deeper layer where there's a concern with some, what I would call perhaps more systemic questions or issues that pertain to ISDS, which is, for example, is this dispute mechanism, which was a sort of settlement mechanism, which came out of sort of a private dispute system, is it adapted or appropriate for the kinds of issues that arbitral tribunals are now addressing, which are largely public law issues? Or, is the asymmetrical relationship that this was based on between an investor and state, is that still valid? So I think the criticisms are at a number of different levels.
Oh, and what has been the reaction of arbitration community to this criticism?
I think the reaction has changed over time. I think perhaps initially the reaction, if I could say, of many in the international arbitration community was perhaps somewhat dismissive, in that we felt that many of these criticisms were either unfounded or had been addressed through reforms that were happening within the system. And transparency is a good example of that, where the system really has taken on board that criticism and has been trying to reform. We have, the 2014 sort of UNCITRAL rules, we have the Mauritius Convention, we have various amendments to institutional arbitral rules addressing the issue of transparency. I think that perhaps was the initial reaction. I think when the arbitration community sort of came to appreciate both the breadth and the depth of concern, I think perhaps another problem is that we were addressing the wrong audience in trying to defend ISDS. Maxime, you probably would have seen there have been many international arbitration conferences devoted to this topic, but in a sense, you're sort of already preaching to the converted. I think now we are at a stage where there's more of an attempt to grapple with some of the sort of systemic issues with ISDS and to involve, a broader group of stakeholders in that discussion. And the UNCITRAL Working Group 3, which is addressing ISDS reform, I think is a good example of that. So I think we are sort of now coming back to the right path and engaging all stakeholders in that discussion.
Well, thank you, Jennifer. And now I think the time to speak about the prognosis. What is the prognosis for further development of the backlash process, and will it continue in the long-term perspective, in your opinion?
I think, Maxim, in answering that question, I guess what we need to be aware of is that the ISDS system is still relatively young, and that can often be forgotten. So we really only saw investment arbitration taking off sort of the mid-1990s, sort of early 2000. And so I think in that context, it's normal that you would expect to see certain growing pains. It's normal that you would expect to see perhaps that the nature of the disputes that are being addressed by the system have changed over time. And so, notwithstanding that it's been a relatively short period of time, I think, the ISDS system has shown that it's capable of adapting and it's capable of change. I mentioned transparency, but, there are other examples that we can mention, developments around participation of non-disputing parties, disclosure around third-party funding, issues relating to diversity. So the system is trying to address these criticisms. I think what's not yet clear if we look towards the future, or at least is not clear to me, is whether the change will continue to happen incrementally, which is essentially how we've been addressing it at the moment, or whether it will be just more of a sort of wholesale reform of the system, which is what is being advocated by a few of the critics of ISDS. And I guess when we're having that discussion, we need to be relatively realistic. And I'm not certain that any of these reforms, whether it's incremental or wholesale, will necessarily be able to address all the criticism of ISDS for the very reason that I mentioned in response to the first question that you raised, Maxim, which is not all of this criticism, I think, is directed necessarily at ISDS, and I think some of it reflects, broader concerns, for example, with globalization. I guess if I go a step further, even though you didn't pose this question, but I know this question is happening in the discussion on ISDS. Do I think that this sounds the death knell of ISDS? I would say no, for various reasons. We've seen, while states are withdrawing from, for example, the ICSID Convention, many more states have actually ratified it. I think most recently last year with Djibouti was ratified the ICSID Convention. I think we all realise in the community that there are legitimate criticisms that do need to be addressed, and certainly those that we are within our reach, we should be attempting to address. But I guess coming back to the most basic point, and I see this in my practice, it is a very valuable mechanism. There are situations where recourse to domestic or local courts is simply not an option. And we all know from history the difficulty in having a state, through diplomatic protection, espouse your claim. And so in certain circumstances, ISDS really does provide the only means of redress. So I think it is an important mechanism that will stay, but with obvious, changes that we're seeing now.
Well, thank you, Jennifer. And now I would like to say that there are many proposals how ISDS mechanism can be reformed. And one of the proposals was raised by the European Commission during the negotiations with the United States of America. The essence of this proposal is the establishment of Multilateral Investment Court instead of arbitration mechanism of investor-state dispute resolution. What do you think about the viability of this proposal and its benefits and risks?
Yeah, so as you mentioned, so one of the proposals sort of largely spearheaded by the European Union has been this discussion of a permanent court. I think in the context of the US-EU discussions, it was very much that, a permanent court, having an appellant mechanism with the arbitrators, I think, being appointed by state parties in equal measure. We also see discussions around sort of a multilateral investment court, which is happening in the context of Working Group 3. In terms of advantages, I guess, the main advantage that I can see is greater coherency or consistency in awards, in the reasoning of certain substantive protections. I guess I say that with one caveat is, that is not always desirable or achievable, given that we have to bear in mind that we are often interpreting different texts and different BITs, obviously with different factual backgrounds. So with that caveat in mind, I think, one thing that we can be sure is we'll hopefully have greater consistency coming out of a permanent court. At the same time, there are, I think, quite a few risks. It certainly, I think, could make the process more political as opposed to less. And I think that's what we've seen, or at least has been the experience of a lot of permanent international courts that exist, such as the International Court of Justice is one example. I think there has also been a discussion or concern in the community about whether these judges will necessarily have the necessary expertise. I mean, one of the advantages of the ad hoc system is that, obviously, to the extent it's bespoke, you can choose arbitrators that match the particular dispute in terms of their expertise. I think another concern is that, given with a permanent court the judges are going to be appointed exclusively by states, you sort of have the same concerns about independence and impartiality emerging. And the idea of adding an appellate mechanism obviously does raise concerns about, is this going to make the proceedings longer? Is it going to be more costly as opposed to less costly? Of course, cost and duration being another criticism that is often levelled at ISDS. So I think there are advantages and disadvantages in the discussion of a permanent court. I guess, coming back to our earlier discussion, what we should realise sort of in having this discussion is that, even if there is going to be a permanent court, it's not going to be a panacea for all the perceived ills of ISDS. It's one possible solution to address certain concerns.
Thank you, Jennifer, for your answer. And one of the reasons that are raised by the states in the process of backlash and necessity to reform the ISDS mechanism is the necessity to change the balance between the interests of investors on the one side and public interest of the state on another side. And what is your opinion about the impact of backlash and possible ISDS reforms on the level of investors' protection?
Yeah, no, it's a good question, Maxim. I think because a lot of the debate on reforming ISDS so far has been on the procedural aspects and less discussion maybe around substantive obligations. That being said, I mean, we have seen, the renegotiation of investment agreements which address substantive protections, and there's certainly a lot of debate now around the possibility of counterclaims by states which would attempt to address this imbalance that you mentioned. I think as a general statement, and looking at the renegotiation maybe of BITs, I don't think that has necessarily led to a dramatic narrowing in investment protection. I mean, on the contrary, in many cases, I think what we've seen happening is states redrafting some of the substantive protections in BITs to reflect the existing sort of arbitral jurisprudence and practice. And if we take one example, with the renegotiation of BITs, we're seeing sort of an express acknowledgement of the host state's right to regulate, which is already, as you know, recognised in arbitral jurisprudence. And I think that comes back to my earlier point, which I think we need to appreciate that the first generation of BITs, a lot of them done in the 1990s, were drafted really before, arbitral ISDS took off and before we had many of these cases and interpretations of the relevant provisions. So I think it's only natural that states now revisit the BITs and make sure that they are addressing what was the original intention or what is now the intention of the parties. So in many cases, I think with investors' rights, what we're seeing is perhaps more detailed, a more nuanced expression of investors' rights, but not necessarily more restrictive. And I mean, that's a general comment. I mean, there obviously are examples of states who are imposing, significant restrictions. At the same time, I think by enshrining sort of this possibility of states to bring counterclaims, by emphasising the right to regulate, the right to sustainable development, environmental protection, there is a rebalancing here of rights between investors and states that is taking place. And I think that is to address part of the criticism that we have discussed, which is that this sort of asymmetric relationship that perhaps once characterised ISDS no longer holds true. And so, I think we'll see the state playing a much more active part in the disputes.
And now we proceed to the second part of our interview that is traditionally called Questions in Brief. I will address small questions and I will expect the brief answers to them on your side. Now, are you ready, Jennifer?
I'm ready, Maxim. Yep.
So let's start. Why you have decided to specialize in investment arbitration?
So my background is public international law. So I think I have a natural attraction to investment arbitration. But perhaps more importantly than that, it's this opportunity to really immerse yourself in the politics, in the history, in the culture of different countries that has attracted me really to investment arbitration.
What things inspire you most of all in international arbitration?
I mean, I've been doing it for 20 years now, Maxim, and I can say I find the subject matter sort of endlessly fascinating. I mean, the opportunity to be working on cases, either dealing with sanctions, expropriation. I'm always fascinated by the underlying subject matter. Another thing I think that I've found inspiring by international arbitration, perhaps as opposed to practicing purely domestic law, is I just think there's more of an opportunity for creativity, and that's something that I appreciate.
If you had two cases with the same level of fee, what would you prefer, investment or commercial arbitration case?
I'm not sure if I can say, Maxim. I think, I've tried, I enjoy both. And I've consciously tried to keep a diverse sort of practice where I have the opportunity to do both investment and commercial arbitration. So I don't think I can say to that question. I think I would like to keep an equal mix of both cases.
Did you start your career working on investment or commercial arbitration?
I actually started with commercial arbitration. So my first case was a construction case in connection with Beirut International Airport. And I did a lot of general commercial cases when I started my career. And then my first, I think, real investment case was in end of 2004, beginning of 2005, which was the UCOS arbitrations, but obviously beginning at the jurisdiction phase at that point.
Thank you, Jennifer. What is the main difference in work of counsel in commercial arbitration and investment arbitration?
Certainly the timeframes that you're working against are different in investment and commercial arbitration. I think the focus is also very different. I mean, in investment arbitration, you can't really afford to focus, just on the particular dispute or the transaction. You really, and this comes back to why I like it so much, you really need to delve further into terms of understanding, the politics, the history, the culture, and, that can sometimes span 10, 20 years of a country's history. I mean, these sort of disputes don't really often arise overnight, and there's a lot of background and context. So the focus I find very, very different as well when one's working in investment or commercial arbitration.
So what role in international arbitration do you prefer more, to be the party's counsel or to be an arbitrator?
These are all difficult choices. I think at this stage of my career, I would probably still say legal counsel. I guess for two reasons. I enjoy the strategy a lot. I really like constructing a case and the adrenaline that sort of comes with a hearing. You know, it's I think the only time as counsel where you're not really controlling all the levers, and there's still that excitement of participating in a hearing that I enjoy.
Oh, if you had the possibility to change one thing in international arbitration, what would you change?
I think it's a thing that's most commonly cited, but largely because it's true. I think costs still remain prohibitive in international arbitration. So I'd like, I guess, to see more proactive case management by tribunals, but also, I guess, at the same time, obviously, more receptiveness from parties to being able to reduce both costs and time in arbitration.
Can you name your achievement that you are most proud of?
I'd probably say the merits hearing in the UCOS arbitrations, just because it was the culmination of many years of hard work. Also working in a team which was very sort of close and dedicated. So there was a lot of sort of fulfillment of getting to the end of that process.
So thank you, Jennifer. And my last question, what is your main advice to young practitioners who make their first steps in this difficult but very interesting world of international arbitration?
I think it's an advice that was given to me, but I find that it sort of rings true, which I think it's very important to get for young practitioners to get a firm grounding in one or more domestic legal systems before venturing in to international arbitration, and a lot of it which involves comparative law. I think there is a temptation sometimes to skip that step, thinking of investment arbitration as sort of transcending legal orders, which it does. But I think in terms of legal training, it's very important to sort of have a rigorous legal training in a domestic legal system.
Thank you, Jennifer. Thank you for your time, for your quick and honest answers to my questions. I hope we will combat pandemic in close time and we'll be able to have EEDRF in the next year. And we hope that you will visit us and will join our events as well. Thank you.
Thank you very much, Maxim. I look forward to my next trip to Minsk. Thank you.